Hello neighbor, I'm Robert Burns, and it is such a delight to be back with you immediately on the heels of our recent elections. I hope everyone was pleased with the outcome. I know everyone is ready to now take a deep breath and let's proceed on, because it's going to be a couple of years now before we'll have any more meaningful elections. So it's time to get back to putting on our sound off piece with a little bit more regularity. And on today's sound off piece, I want to focus in on bringing everyone up to speed on the developments in the civil litigation trials against our Inspector General Stephen Street with the Office of Inspector General's office. Now, let me just say this. On December the 8th, I believe it was, investigative reporter and investigative journalist Tom Aswell came out with an outstanding piece which emphasized that Mr. Street's office has spent considerably more on out-of-state travel than it has on in-state investigations. And we're providing you with a direct link to that article. I would encourage everyone to go and to look at it. But today I'm going to just take a little bit of time to bring you up to speed on where everything stands with regard to the civil litigation regarding criminal investigations that basically blew up in Stephen Street's face, and those two being Murphy Painter and Corey delaHoussaye. Most of my time will be spent on the delaHoussaye situation, because let me just briefly say Corey delaHoussaye, for those of you who may not be familiar with him, we have a link that you can click on to go and see a very detailed interview with Corey delaHoussaye that was conducted back in June of 2015, wherein provided the opportunity for him to elaborate upon the tremendous level of corruption that he observed in Livingston Parish in the aftermath of Hurricane Gustav, and the nightmare that his life became as he became a Federal Bureau of Investigation's informant in reporting all of that fraud. I would encourage you, if you'd be so inclined, to go back. You can get all of the specifics of that material. It's a very in-depth interview along with supporting link to it. Now, at that time, Mr. delaHoussaye was actually under criminal charge himself for allegedly having submitted some $6,000 in invoices out of $2 million of his billings as a FEMA contractor to Livingston Parish. He predicted then that, that there was no way that this was ever going to pan out, and that he was guilty of absolutely nothing. He was very accurate in that prediction. And then I want to provide you a link also wherein Mr. delaHoussaye filed suit against the Office of Inspector General. That was in February of 2016, about 10 months ago. And he openly encouraged all of his viewers to lobby your legislatures to abolish the Inspector General's office. And then I'll provide you a link wherein I recently confronted Inspector General Street at the Baton Rouge Press Club about these two debacles, and you will see Mr. Street kind of have basically meltdowns with regard to both of them. At the point in that video, what I had told you was that there had been a hearing on a peremptory exception with regard to the Corey delaHoussaye matter, which the delaHoussaye matter is relatively new. So I'm going to focus on it first. We'll cover Painter right at the very end. But there was a peremptory exception hearing, and Judge Caldwell on July 25th had granted the OIG's peremptory exception. And I had stated truthfully in that video that in all likelihood Mr. delaHoussaye's case may be on life support because of the fact that in all the situations that I have observed in Judge Caldwell's courtroom, he provides the opportunity for you to amend the petition after a peremptory exception has been granted. He has to do that by law, but pretty much it's, from all intents and purposes, usually it means game over. Judge Caldwell, in granting the peremptory exception of no cause of action, said that Mr. delaHoussaye was going to have to provide actual verbiage of how his character had been defamed. Mr. Robert, Al Robert Jr., who serves as Corey's attorney in this matter, he did amend the petition. I'm going to give you a link for the amended petition. to try and cure the peremptory exception. And basically, when they, naturally the OIG filed yet another motion for peremptory exception, and there was a hearing held on it in late October. And in a nutshell, what Judge Caldwell said is that he had just recently had another matter brought back down to him from the First Circuit where they had overturned a decision he made, and here's what they said. The First Circuit said that if the investigating agency did not have jurisdiction, then that opened up a claim for invasion of privacy. All right? This was kind of like manna from heaven. Al Robert learned about this case. He readily said he wasn't familiar with it. Judge Caldwell referenced it as Mr. Robert was arguing his case for the denial of the peremptory exception. And so it was kind of like manna from heaven falling down. And so, because there can be no doubt whatsoever that the Inspector General's office did not have jurisdiction to go in and raid Mr. delaHoussaye's home at 5 a.m. in the morning, guns drawn as if he was a drug dealer, seize 19 terabytes of his computer equipment. Remember, we're all talking about $6,000 of allegedly, invoices for his own billings versus $58 million in fraud that he served as an informant on, okay? Them going in and raiding his home like that would literally be no different than if I had gone in and raided his home. And had I done that, well, naturally far beyond just a civil suit, which is all the Inspector General's office is having to worry about, naturally I would have been prosecuted and thrown into prison for having done that. All right? So Judge Caldwell said that in light of him being overturned on another case, wherein they said, hey, if they had no jurisdiction, an invasion of privacy cause is going to be able to be succeeded over a peremptory exception. So Judge Caldwell denied the OIG's peremptory exception as a result of the fact that he said, that's not something he had taken into consideration, and he had just kind of glossed over the defamation aspect. But he said the invasion of privacy, based on the ruling from the other court case, would appear to rule the day, and so he was denying the peremptory exception. Now, somewhat shockingly, the Inspector General's office has gone ahead and appealed Judge Caldwell's decision to the First Circuit Court of Appeals, which is interesting because you would wonder, okay, what are they going to do? They're going to issue a ruling that would contradict their other ruling for the case that Judge Caldwell had referenced? But all I can do is tell you that they did appeal. We're going to give you a direct link for the appeal that they launched with the First Circuit Court of Appeals. And I think what is really going on here is that they're just trying to wear Mr. delaHoussaye down. I can guarantee you that's what they're doing with Mr. Painter. Preston Castile and Taylor Porter, the firm, they could give a flying flip. All it is billable hours to them, okay? But we are racking up, we as taxpayers are racking up absolutely staggering defense costs associated with our current Inspector General, okay? I'm sure it's going to take months before they even get a hearing date on this. I would expect it would be overturned. I would hope they're not going to appeal it all the way to the Supreme Court, but who the hell knows? But at any rate, if there's one reason they're having to do this is because if they don't succeed here, I don't see any way that this case doesn't go on to be tried on the merits, all right? And I'm going to tell you right now, you do not want to be the defense attorney having to defend what the OIG did here. There is not a juror out there that is not going to be sympathetic to a man who was serving as a federal government informant about $58 million of fraud, and he has his house raided at 5 a.m., his kids scared half to death, 19 terabytes of his computer. They shut his business down in doing so. So there are very real damages here as a result of the OIG's action. You do not, if I'm the defense attorney, last thing I want is all of that being aired out in front of a jury. So I'm sure they're trying every conceivable mechanism they can. and all the while racking up costs, and they're delaying. One day they're going to have to face the music here, and probably at that point, my guess is they would go to Mr. delaHoussaye and try to look at making a settlement, because I think they are in an utterly disastrous position to try this case. I felt that way about the CNSI trial. To Jeff Landry's credit, I think he quickly surmised that, hey, with the outrageous witness tampering that had gone on in that trial, that Louis Oglesby was going to have an absolute, he was going to have a field day if that thing had proceeded on to trial. And, let me just say this. I think Al Robert will be quite effective at conveying to the jurors exactly what transpired in here, and it was nothing more than the Inspector General's office being sicked on to Corey delaHoussaye as a result of, in the general administration's mind, a whole lot of his supporters didn't get paid on what were fraudulent contracts and fraudulent invoices in the first place. So that's where that sense. You can feel free to go in and read the appeal in depth if you would like. But I find very interesting one of the arguments that Preston Castile is making. He is basically saying, hey, look, your beef is not with us. Your beef is with Scott Perilou, the district attorney in Livingston Parish. He's the one that pursued you, and you're just randomly plucking us out, and choosing to pick on us. Your beef is not with us. Well, let me tell you something, Mr. Castile and the OIG. When you come over to my home and you raid it at 5 a.m. in the morning and you take all of my computer equipment, and I'm told took his personal tax returns and things of this nature, and you keep them over in your office for an indefinite period of time, and you shut down my source of income, I hate to break this to you, but I got one hell of a beef with you. All right? Yeah, I got one hell of a beef with you. So I don't believe your little argument that, your beef is not with us, it's with Scott Perilou. I don't think that's going to gain a whole lot of traction, and nor do I think it's going to negate the illegality. This was an illegal search and seizure. Stephen Street knows it was an illegal search and seizure, and if he felt otherwise, all he had to do was take the First Circuit Court of Appeals up on their offer to go before Judge Ricks and have a hearing on the constitutionality of the search and seizure. Instead, Stephen Street just folded up tent, and Scott Perilou said, we're dropping the charges. An admission that they knew this was going to be deemed to be an unconstitutional search and seizure. So that's where we stand on the Corey delaHoussaye matter. If it had ended, the taxpayers' cost of defending this would have been pretty minimal, but now that it looks, the very fact it's on appeal now on the peremptory exception are going to make the charges just rack up. But if this thing goes on all the way through trial, we're talking about an ungodly amount of defense cost. And I don't even want to think about what the ultimate judgment may end up being on here, because I'm telling you right now, as I said earlier, if I'm the defense attorney, I do not want to be having to defend what this agency did in that particular case. All right. Oh, and by the way, Corey delaHoussaye has just recently formed a brand new blog, CoreyDelaHoussaye.com, where he'll be tracking going forward. It's only about a week-old blog. We're going to give you the link to it. You're welcome to keep track of things that transpire in his life as he continues on this journey of having been a federal government informant. And he asked for suggestions from the public about ways that maybe this type of thing may not be happening to them, one of which I have already contributed to, saying I believe the Inspector General's office needs to be abolished because not only is it costing us directly for the outlays of what is just an absolutely, I believe, incompetent operation over there, but we're also having to pay staggering defense costs for all the screw-ups that they make entailing Mr. delaHoussaye and Mr. Painter. Now, I want to move on to bring you up to speed on the current development within the Murphy Painter situation. In sharp contrast to the Corey delaHoussaye matter, which is relatively new, not even a year old, the Murphy Painter situation has now dragged on for 6 years. There have been 4 amendments to the petition. As I told you in our last update, Judge Clark, and I do think she did well to say this because she's right, the petition became so convoluted that she informed Al Robert Jr., he is also representing Murphy Painter the same way he is Corey delaHoussaye. she said, counsel, what you really need to do is go back and draft the amendment from scratch, because at this point there are so many defendants, there's so many players, everything is so intertwined and it's so convoluted that nobody can sort it all out. And so he did that. Mr. Robert did that, and he amended the petition. And of course, right off the bat, here come more peremptory exceptions. And now we do have a multitude of defendants in that. There again, Preston Castile is representing several of them. He's done the bulk of all of the work to this point in that matter. But Miss Sherry Morris, who also happens to be the attorney for the Cosmetology Board, she was assigned to, I believe, two of the defendants, one of whom is Shane Evans, to defend them on behalf of the Department of Revenue. She procured that particular contract. Now, let me just say this. The peremptory exceptions that the OIG filed were scheduled to be heard on Monday, December the 5th of 2016. I try to never miss a court hearing, and of course I was there. If you will remember right, it was a pouring down rain, not the best weather conditions, but I wanted to be there because I don't like to miss court hearings pertaining to this matter. And so we get there and come to find out that, well, it turns out that Miss Morris has a conflict. Okay, now Preston Castile is there, and he's representing his defendants in the matter. But Judge Clark says, look, I wasn't told, nobody told me anything about any conflict. Now I'm finding out that, well, Miss Morris has a conflict, so she couldn't be here. Now let me tell you what that conflict was, okay? There was a Cosmetology Board meeting on December the 5th, something she's known about for a month, okay? Miss Morris also had a court hearing that very morning in Judge Caldwell's courtroom. It pertained to the litigation about the eyebrow separation. You remember that we did a sound-off feature on those folks who were suing the Cosmetology Board. Miss Morris is defending that suit. She let Judge Caldwell know, hey, look, I've got a conflict. We need to continue it. And it was rescheduled for January the 17th. You know, now Miss Morris knows that those Cosmetology Board meetings drag on for an extended period. They had multiple hearings scheduled for that day. So basically, it's no way in hell that she's going to be able to be over there for a 1 o'clock hearing in Judge Clark's courtroom. But unlike the hearing in Judge Caldwell's courtroom, where she had given the courtesy to say, hey, I have a conflict, she obviously extended no such courtesy with regard to her afternoon court meeting. That was readily said. Hey, Judge Clark said, hey, nobody told me anything. All right. So Mr. Robert argued that, Your Honor, I've driven up all the way from New Orleans. I would like to at least proceed with arguing the peremptory exceptions for the defendants that are represented by counsel by Mr. Castile here. And Judge Clark said, no, I don't like the idea of hearing some of the exceptions now and then other exceptions at a later period. So consequently, the entire matter was continued until, I believe, February the 7th or 13th or something like that. And of course, Preston Castile cheered Judge Clark on. Oh yes, it did definitely make more sense for us to do them all at once. And of course his mentality's going off, cha-ching, 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 you know, so now he can bill 3 hours for that day for basically nothing, you know, and then get to come back in February and rebill for the same item that he would have been arguing for in the first place on December the 5th. That is all an effort, in my opinion, that is all in an effort to wear Murphy Painter down, okay? And of course, they have infinite resources of the Revenue Department and the Treasury. That's one of the reasons, keep hearing about all these tax hikes we have to have. A lot of it is to pay for litigation like this that is the result of irresponsible actions on the part of the Office of Inspector General. But we are where we are. Nobody can even get a handle on how much these defense costs are, because if you make public records for the invoices to try to get them, oh, it's part of ongoing litigation, we're not going to release them, okay? So who the hell knows how much litigation expense is entailed in these two matters, but I can guarantee you it is substantial. So that will bring you up to speed. We're probably going to be months away from being able to hear a hearing on Corey delaHoussaye at the First Circuit Court of Appeals. So that basically is frozen in time for probably at least 60 to 90 days. Murphy Painter likewise is frozen in time until February 7th or 13th or whatever date it is, at which time hopefully all the attorneys representing all the parties can be there for these peremptory exceptions to once again be argued. This will be about I'm not exaggerating, this will be about the 20th hearing that has taken place for the Murphy Painter civil litigation. I think you can know how staggering the legal costs for that are. And I just think it's reprehensible that we have a state inspector general not only costing us directly for what I can see accomplishing damn near nothing, but is also bleeding us through these type of actions. Both of them, make no mistake, Painter and delaHoussaye were direct sick'em actions from Governor Bobby Jindal, and we're all paying the price for it all these years later, because Bobby Jindal had aspirations as ludicrous as they seem to become the next president of the United States, all of which obviously he now knows, everybody knows, he was completely blind to ambition and wasting his time, but we're still paying for his legacy. So this is Robert Burns. I hope all of you will enjoy a very Merry Christmas and a Happy New Year. We got several sound-off features lined up for you in coming days. I think you'll find them all very interesting. They all involve corruption. I'll let it go at that. And, you know, that tends to be what I like to focus on. So I hope everyone has a very Merry Christmas and a Happy New Year. And we look forward to bringing you our next sound-off feature in the very near future. Thank you so much.